Welcome to today's program titled Regulatory Shifts and Risks: What's Ahead for False Claims and Whistleblower, Bankruptcy and Franchise Law in 2025, the second session of our Commercial Litigation Outlook webinar series. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to our moderator for today's program, Ken Wilton. Ken, you may begin.
Still don't understand how to use unmute. Hi, my name is Ken Wilton. I'm a partner here at Seyfarth in the Intellectual Property Department. It's my pleasure today to be moderating a panel with four of my colleagues. And we're basically riffing off of our Commercial Litigation Outlook, which we published earlier this year. And we have a series of webinars, this being the second one, where we're covering individual topics within that Commercial Litigation Outlook. Today we'll be dealing with false claims and whistleblowers, bankruptcy and franchise regulation. And so to kick off the discussion, let's take a dive into the False Claims Act and whistleblower litigation status. And including a recent Seyfarth decision, which I know Teddy Arnold is going to be talking about. The two panelists will be talking about this are Teddy Arnold, who's one of my partners out in our Washington, D.C. office and in our government contracts group, and Chris Robertson, who's a partner in our Boston office and in our litigation group. Both of them co-chair our False Claims, Whistleblower, and Internal Investigations group. So without further ado, Teddy, how do you see the recent ruling in Seyfarth affecting False Claims Act matters?
Yeah, thanks, Ken. So for those who haven't heard, it's sort of a seismic quake was set off, I guess about a year ago in the Middle District of Florida in the Seyfarth decision, Seyfarth versus Florida Medical Associates. This is a False Claims Act lawsuit. It was brought under the key tam provision of the False Claims Act, which, as many know, allow private whistleblowers, otherwise known as relators, to essentially file suit on behalf of the government where they believe there's been violations of the False Claims Act. So it's essentially fraud. What was significant about this decision was, as you normally see, the defendants in a False Claims Act lawsuit, after it's filed, often try and move to dismiss the lawsuit for a number of grounds. This one, the defendant, the Florida Medical Associates, moved to dismiss on constitutionality grounds, which has been tried before in lots of jurisdictions across the country over time. And every single time it's been alleged, it's been unsuccessful. This was the outlier in that the court granted the motion to dismiss, essentially declaring that the key tam provision of the False Claims Act is unconstitutional on essentially the same argument that has been tried in the past, that it violates Article 2 of the Constitution, which vests all executive power in the president and requires that officers of the United States be appointed by the president, the courts, or the heads of the departments, and that the relator, well, is a private individual. They're not an appointed individual by the executive branch. And so the court essentially found it unconstitutional, on two different grounds. Two criteria, basically. One was that relators do exercise significant authority by initiating and prosecuting these enforcement actions. That's the power to file these lawsuits, to direct litigation, to bind the government to those legal outcomes. And second, that this position the relator occupies in this lawsuit, it's not transient, but it's rather a continuing position established by law. Both of those two elements coupled together, you have to follow Article 2 of the Appointments Clause under, or according to the district court, and here the key tam provision empowers the relator who is not otherwise appointed. And the court essentially addressed the historical use of this provision because this has been around a long time, and essentially dismissed that, and sort of was able to justify its finding. And so as a result, court dismissed the case, that the relator is not properly appointed. And as you would expect, it's a big deal. It has a lot of wide-reaching implications, and that case is now up on appeal.
And what circuit was that again, Teddy?
It's the Middle District of Florida, so a federal district court in Florida.
So it's before the 11th Circuit now?
11th Circuit, yep.
Assuming it's upheld, what steps can companies take to prepare for the changes in the enforcement landscape because of that?
Well, so what we're eventually going to see is a Supreme Court case on this. It's going to take years. There's speculation that the 11th Circuit won't rule until 2026. If they uphold it, it's for sure going to be appealed to SCOTUS, and that could take several more years. So it's going to be status quo for a long time. I think sort of, what are the implications of this eventually, right? Eventually, if this gets struck down, relators can't bring cases. It's going to have to be the government. So you'd have to see more DOJ enforcement of the False Claims Act. That would call into question, do they have the adequate resources to bring all of these cases that the relators otherwise would have brought? And we saw a record number of those cases just last year. I think it was north of 900 cases were filed by key TAM relators. I think the lesson is for companies who are looking at this and watching this case, and you get embroiled in a false claims suit, and in other districts it's still being shot down. So defendants are trying to move on constitutional grounds and not being successful. At least I've seen cases even in the last few weeks where this ruling has been denied. But I think it's a safe bet to at least make the motion, so at least you preserve the issue for appeal in case there is a change in the law in the coming years. So, I think you can see this as even a post 12b6 motion, something like a motion for judgment on the pleadings under Rule 12c, and maybe a summary judgment motion. You definitely want to preserve this, in your lower court case while the cases make their way through the appellate courts, because you never really know what's going to happen, and there's sort of a lot of open questions around ultimately what will the court hold. SCOTUS, there's 3 judges on SCOTUS who have expressed skepticism as to the constitutionality of that provision, and we'll have to see what the makeup is of the court by the time it reaches their desk, and what that ruling would ultimately look like.
I know there are some changes or proposed changes to the False Claims Act and the 2025 National Defense Authorization Act. Can you speak to those a little bit?
Sure. So the big tool the government uses, the False Claims Act, 31 U.S.C. 3729, widely used by the DOJ to prosecute fraud. There is a lesser known administrative remedy, so not a statutory remedy, but administrative remedy for false claims and false statements that is used when the government, the DOJ, otherwise declines to prosecute false claims cases, and thereby they would essentially defer to the agencies to pursue those claims in an administrative proceeding. This is known as the Administrative False Claims Act. It used to be known as the Program Fraud Civil Remedies Statute, I believe, so it's got a new name. It essentially, it's a tool that agencies can use to resolve relatively small dollar fraud in which the cost of litigation might exceed the damages the government could recover. And so to that end, you've got civil penalties up to $5,000 for each certified written false statement and false claim. And it allows you to get damages of 2 times the amount of the false claims, different from the primary statute, which allows you treble damages, so 3 times. This is a 2 times remedy. And of course, just like the parent statute, it does not have to require a showing of specific intent. Just some kind of actual or constructive knowledge of the falsity is sufficient to find liability. So it's essentially a negligence statute, if you will. It's usually the inspector general who's the one spearheading, the investigation. They've got subpoena power, and there's sort of an internal hierarchy to an agency as to how they would deal with these kind of proceedings. You don't hear about them a lot, I think, because it's very internal to the agency. It's not like it's a published case that you can read about. in most instances, but we know it's out there. We know it's a tool that does get used. It's been seldom used. With the new changes in the National Defense Authorization Act, they tried to buttress the enforceability, or essentially the potency of this remedy. They've raised the maximum amount for claims from, it used to be 150 grand, now it's $1 million. So trying to incentivize agencies to bring these. They've also included reverse false claims now within the scope of what can be adjudicated in these administrative proceedings. Reverse false claim being you failed to transmit money back to the government that you otherwise received. It's got a number of other, facets to it. It's got detailed semi-annual reporting. So there should be annual reports that are filed, so we'll know at some point how widely this is being used. And essentially, the amendments also expand the pool of officials that can preside over these hearings. That also includes members of the boards of contract appeals. And the statute of limitations was tweaked to mirror that of the parent statute. So it's 6 years for a violation, or 3 years after the material facts are known, with an outer limit of 10 years.
So do you think these changes are going to cause federal agencies to be more aggressive in using the Administrative False Claims Act and as an enforcement tool?
I mean, one would think, there's right now, the False Claims Act is the big popular statute that everyone's talking about. That's what the current administration is wielding, especially related to the DEI executive orders, which we might talk about in a little bit. But I mean, essentially, you could see more of these administrative proceedings where the DOJ doesn't want to pursue them, or where the DOJ doesn't have the, essentially the bench to prosecute all of these sort of false claims cases that they're sort of threatening. So you can definitely could see an uptick in this for certain. It just sort of, it just depends on the priorities of the administration, the priorities of the agency, and of course their own sort of internal resources. What can they devote to sort of pursuing these?
Let's switch gears just slightly and talk about the whistleblower pilot program, the DOJ's whistleblower pilot program. How is that going to influence whistleblower reporting, corporate compliance, and how corporations react to these kinds of claims?
Sure, and thanks, Ken. And I think what we're seeing, and obviously there's a lot changing in real time with sort of how things are being reported. And as Teddy mentioned, we've talked more now about sort of DEI and reporting these DEI issues to the government than I think we thought we would be. But that's obviously a significant concern, is that, there's now this reporting avenue within the Department of Justice for employees to report, what they consider violations of the law. And if, in the DEI spaces we've seen there's that concern, then we expect to see those complaints being made. But I think more broadly, the way the program was set up, and to Teddy's point about, what happens with the constitutionality of the False Claims Act, I think what we're going to see is, are there basically double tracks? So would I, if I had a claim that I thought, was a fraud, would I file both with the government under this whistleblower program, but maybe at the same time file a claim under seal, as you need to do as a False Claims Act case, and then see which one actually tracks more quickly or tracks to a successful resolution? The remedies at the end of the day, if you're successful, are roughly the same. So from a standpoint of thinking about sort of, if you're a plaintiff's lawyer and you represent an employee, walks into your office and says, I have this issue, thinking about where are my avenues to seek recovery, this is just another tool in the toolbox, which now you can go to the government. I think the important thing to understand, though, is, and we recently attended a seminar where with the folks in the brokerage industry and the financial services industry, and they made pretty clear, this was the head of the CFTC, the head of the SEC, the head of FINRA, that it's still the case that more often than not, and some say even to the 70 to 80%, that an employee will come internally before they go to the government. So all of this, to in terms of what should we be doing internally, it's confirm that your internal reporting program is as up to date as it can be, but also that you're responsive. Most whistleblowers aren't they actually believe in the organizations they work for and bring these issues up because they want genuine change, not because they're looking for a check, But if they're ignored, and particularly if they're ignored, and this came straight from the heads of these enforcement agencies, if they're ignored more than a few times, then they will absolutely go get a lawyer or go to the government. And the issue for any of these claims is you often don't know about it until a decent amount of investigation has already been conducted. So, for example, a False Claims Act case is going to be filed under seal. The government's going to look into it. They may do months of investigation before you're even aware that there's a claim that's been filed. Similarly, that may be the case if someone files something with the Department of Justice. You'll likely know at some point because they'll probably issue a subpoena, but they may not issue that subpoena to your company first. They may go to other folks, they may go to your suppliers, your vendors, and try to understand sort of what the flow of funds is, and then come to you. And because you didn't handle that complaint right out of the box, you maybe find yourself, really trying to catch up versus having a robust program where you can take that intake. And even if there is an issue, you can be ahead of it before the government's ahead of you.
Well, that kind of leads to, there have been some recent decisions expanding the rights of whistleblowers. What can a company do to, I don't know, kind of avoid retaliation claims, from some action taken by the company in light of the whistleblowing?
Yeah, I mean, anytime necessarily when there's a retaliation claim, there's some adverse action that the employee is saying has occurred relative to their employment. Obviously, termination is easy. If you've terminated someone, clearly that's an adverse action, but there can be employees that will complain about promotions or other things that happen internally. And most of this is documentation. Simply because someone is a whistleblower does not mean that they are tenured. It doesn't mean you can't take action. But where we find the biggest issue is the company hasn't sufficiently documented or hasn't sufficiently supported the independent reason for taking the action they've taken. And the closer it is in time, the more difficult that becomes. And what we've seen in the cases, and we referenced these in the Outlook piece, is that the courts have expanded this a bit. They're making it somewhat easier for the employee to at least get to a point in the case, if not at summary judgment, potentially even to trial, on issues like causation, state of mind. Obviously, Murray versus UBS was the big case in the whistleblower space last year. And it was, you don't have to have retaliatory intent. It's just if the fact that someone was a whistleblower factored into a decision or was a part of the decision in any way, shape, or form, then the burden is going to shift to the employer to demonstrate by a preponderance of the evidence, by clear and convincing evidence, actually, that there was an independent, non-retaliatory reason for the action you took. So the standard has gone up, but it really, as with all these things, comes down, and particularly in litigation, it comes down to proof, and it comes down to documentation, and it comes down to credibility. And so those are the things that you need to be thinking about if a situation comes up and you ultimately have to take some action. Do we have the appropriate evidence and supporting evidence that this doesn't look pretextual, that we actually have an independent reason to take the actions we took? For example, someone, is, quote, insubordinate. We see that a lot. Do you have the evidence for that? If someone violated a policy, what policy? If someone removed documents, that are confidential, do we have the records of those? Because ultimately it's going to come down to proof.
So finishing up on the whistleblower topic, given the trends in False Claims Act enforcement and such, and whistleblowing, are there specific industries that should be concerned that would be affected by these kinds of trends? And sort of the corollary to that, what proactive steps can they take to protect themselves?
Yeah,
I'll let Teddy address the government contract side, and then I'll jump in. Go ahead, Teddy.
Yeah, I mean, I think so. I don't know that. I mean, right now, I don't know if it's industry specific at this point. The big action is on DEI. Historically, the False Claims Act is predominantly used in the healthcare space, and that will probably forever and always be the case. And I think the statistics from the recent years show that the action is occurring with the opioid epidemic, with pandemic fraud. Cybersecurity is an emerging topic. And then you've got your small business fraud, Right now we're seeing customs fraud. I think with the tariffs, I could see that being front and center now. But, I think it's probably not industry specific that's any different than what it's historically been. It's just going to be more sort of issue driven. I think right now DEI is going to be it seems to be the big policy position of the Trump administration that, and they're it's baked into the executive order that your compliance with all federal anti-discrimination laws is material to the government's decision to pay under the False Claims Act. That materiality language, directly geared towards trying to check that box to tee up potential false claims liability. So I think, and there's a certification that accompanies that's at least required in the executive order. Just a caveat, that is working its way through the courts. We don't know if that's legal or not. So the outcome on that is TBD. That's sort of the trends. I mentioned that the key TAM suits the numbers are way up. The dollar recoveries are at least up in the last 3 years. I think it's just under $3 billion. But I think, something like since 2000 or maybe since the 80s, something like $80 billion has been recovered. So I don't see the action slowing down. I see it being accelerated. I think, we'll keep an eye on the key TAM provision, what happens with that in the coming years. And the DOJ, what is there? It's very much sort of policy driven, what they elect to pursue, what they don't elect to pursue. I think on sort of what can you do? You could do a whole webinar just on sort of what can you do in your ethics and compliance programs. It's focused on what you have control over, and the thing Chris already mentioned a lot of these, which is just, strengthening your internal controls, your audit mechanisms, your training of your workforce, test your hotlines, make sure you're giving it due diligence, you're investigating, you're following up, you're chasing down all the leads of potential misconduct so that you can, report to the government before a key TAM later files a lawsuit, right? The whole goal here is to self-disclose and get ahead of the problem, assuming you have a problem.
Yeah, and the only thing I'll add is it's always, where's the money? And so, keeping an eye on, to Teddy's point about what we've seen over the last couple of months, if these tariff issues, result in substantial amounts of money that will be paid or unpaid based on, for example, evading them, that's something that obviously if I'm a whistleblower and I see that, my company's importing materials and they're evading these tariffs and that all of a sudden becomes a really big number and I can get a third of it, I'm starting to think maybe that's the time to go talk to a lawyer and see if there's something there. So it's always trying to be a little bit of a step ahead of where the money's going to be. And that obviously is changing in this environment a little bit.
Well, thank you, Chris and Teddy. Appreciate it.
Thank you, Kevin.
As we continue to monitor economic trends, which seem to change by the hour, right now top of mind is the unexpected sell-off in the bond market. And all of these things are shaping opportunities and challenges for businesses. And so helping us to walk through that is one of my partners, James Soka. He's in our Bankruptcy and Restructuring department in Chicago. And James, welcome.
Welcome. Thanks a lot, Ken. Happy to be here.
I'm glad you're here too. Especially you can explain everything going on today. But let's start with a broader question. What kind of trends are you seeing in bankruptcy so far in this year, in 2025?
So far, we are seeing an expected increase in bankruptcy filings. Through the first quarter, bankruptcy filings overall were up 10% from the prior year. Digging into those numbers, commercial bankruptcy filings were up 2%, although Chapter 11 filings were actually down 7% this quarter over 2024.
So what accounts for the 10% uptick?
So this was largely expected. Inflation is higher costs on both consumers and businesses. Higher interest rate environment that's been persistent in time has, increased costs for everyone that has debt. And previously, debt was, extraordinarily historically cheap for quite a while. So I think as far as households and businesses now, the debt that they have accumulated is more costly to the extent that the rates weren't fixed. So managing that is another big piece as well. So, bankruptcy had been up for a couple of years, really during COVID, we saw historic lows in bankruptcy filings, and that was due to a lot of the government stimulus, low interest rate environment that was going on at the time. And then given that the courts and things were shut down, you had a lot of moratoriums on enforcement and collection of debt. So people had no reason to file. And if you were in default, banks were happy to give loan extensions. And, you know, that was really the environment at the time. So filings were very much down. And, you know, the last 2.5 years, there's been an upward trend in filings. And we got to historical, probably normal levels, and now we're starting to climb a little bit above those, especially on the business Chapter 11 side. Consumer filings are still maybe modest compared to historical trends.
Well, you mentioned that on, I asked my first question that I guess year over year for Q1, Chapter 11 filings are down 7%. Do you have any ideas as to why that's happening?
So I'm actually not surprised with that, given the you know, turmoil in the economy with tariffs. But if you actually dig into those numbers a little bit further and look at them month by month, March filings for Chapter 11 were actually up 20% over 2024. It was really January and February where the filings were lower, and with the inauguration of the new administration and then the promise of coming tariffs, it was causing a lot of companies to reforecast for the year. And if you're potentially going into a Chapter 11, it's important to have an exit strategy and have your financial projections done to make sure you can get a plan confirmed and perform under that plan. So with the unknown environment and tariffs coming on, I think a lot of companies paused and were looking at their numbers and maybe trying to get more information before they filed. But certainly, as we saw in March, the numbers have ticked up, and we are seeing the expected increase in Chapter 11 from them.
Yeah, I've read a few things about tariffs in the last week or so. I'm curious, how does that, I mean, you've already touched on it, how does it factor into what you expect going forward for this year for bankruptcy filings?
Well, you know, I think it's going to participate in higher filings. It's going to be a reason for that. But, you know, in the short term, there's been a lot of volatility, obviously, with what's going on in the stock market. We're on the precipice of a bear market. And, you know, it's a lot of uncertainty, but the tariffs now taking effect, imports are going to cost more. So you're likely to see higher inflation, again, at least in the near term. So you're going to have increased costs, and companies are going to, you know, have to figure out what they're going to do with it. Are they able to absorb those costs? Are they able to pass them on to consumers? Is their business model no longer viable because they can't absorb the costs or pass it on to consumers? So we're going to see this play out through the economy, and some businesses will refocus capital and investment and move manufacturing to different countries or potentially onshore. But that's a longer term process. You know, if you're going to move your manufacturing to the U.S., you have to buy land, you're going to build a factory, you've got to build an assembly line, beta test your product, and roll out. You're really talking 5 years, right? If you commit to it today, in 5 years, you can start manufacturing products in the U.S., assuming you can find the necessary expertise and materials.
Do you expect any of what's going on to impact interest rates from the Federal Reserve?
Yes, but I don't know that we know how it's going to play out yet. You know, there's a difference of opinion. Some people think the Fed is going to hold its line and we may see, you know, no rate decreases or maybe one, and others think this is going to cause turmoil and force the Fed to start cutting rates, even though inflation may go back up. And certainly inflation is going to be key in there, but I really think what's going to likely push the Fed's hand is whether or not we end up in a recession and if unemployment figures start ticking up. And I think if that happens, there'll be tremendous pressure on the Fed to respond with rate cuts, even if inflation isn't under control.
I know a lot of your practice deals with commercial real estate and the bankruptcy side of that. If lower interest rates do come to pass, how would that impact commercial real estate?
So, you know, we were expecting rates to tick down a bit and stabilize. And assuming that were to happen, I think in the commercial real estate realm, what that's going to do is it's going to help build a consensus on valuations, especially in the office space. And what we've seen the last few years with the tremendous decline in office valuations, you've got a lot of borrowers that have no equity left in their property. And there's a tremendous difference of opinion and values just because they have fallen so far. You're not seeing a lot of deal flow yet, you're starting to see properties being given back to lenders, but the lenders haven't necessarily turned around and sold a lot of those. There's been a reluctance to reset the market at this lower rate, but I think if rates went down a bit, that would help stabilize values a bit and allow more deal flow, both in the distressed realm and the non-distressed realm as well.
Do you see any, which is sort of hard to predict in this environment, but do you see any looming surprises that are going to impact bankruptcies in the coming year?
Well, I think tariffs, that's going to be, causing a lot of volatility for the foreseeable future. But, what we've seen in the last 24 hours is, as you mentioned at the top of the presentation, is the somewhat surprising sell-off in bonds that we've seen, which has caused interest rates to actually tick back up. Rates, up 3 days ago were on the 10-year yield were as low as 3.88, I think, and overnight they spiked up to 4.51, indicating a tremendous sell-off in bonds because yields run inverse to prices on bonds. It's perhaps not entirely unexpected because given the losses in the stock market, you have a lot of traders that probably have to liquidate positions to cover losses they've incurred. But it is a concerning trend because typically bonds are viewed as a safe haven. So when you have distress in the stock market and the sell-off, typically money moves into bonds, increasing the prices and lowering the yield, which, lower yields would make at least it's cheaper for everyone to borrow money for debt, including the U.S. government as well as mortgage borrowers, because mortgage rates are largely set off of the 10-year yield. So that's a bit of a concern. You view that in tandem with the fact that suddenly over the last week, the dollar has lost some value. The dollar is also typically viewed as a safe haven and something you would expect to strengthen. But you're seeing bond and the dollar weekend. And if that trend continues, that's potentially a sign of trouble that the markets may not be functioning properly. I think the last thing to look for is the administration's proposal on extending the tax cuts that were enacted in Trump's first term in office. And there's been, some movement that the president is trying to push through and get Congress to finalize this. But with the tax cuts, to extend the prior tax cuts that were already enacted, that would increase the deficit. The estimate is about $4.5 trillion over 10 years. And they're not really offsetting that with extra income. Now, you would have additional funds raised through the tariffs. The high end of those estimates seem to be, 2.5 to 3 trillion over 10 years. And that doesn't account for companies adjusting, trying to get around the tariffs, either negotiating lower rates or moving manufacturing. So that's not certainly going to offset all of the deficit. So then the question comes into, can will the markets respond and allow the U.S. to sell sufficient bonds at affordable rates to cover it? And if not, borrowing costs could skyrocket if the markets don't cooperate. And we saw something similar, you may recall, in Great Britain in 2022 when Liz Truss was elected prime minister and proposed massive tax cuts without any other sources of revenue or spending cuts. And there the pound lost tremendous value and borrowing costs for the government skyrocketed. It caused them to abandon the tax cut plan, and Liz Truss ended up being sacked, and it caused a change in government there. So I would have thought something like that wasn't really likely or possible to occur here, but given the volatility we're seeing with tariffs in the stock market and then the sudden behavior in the bond market, it is cause for concern that, to propose the tariff plan and enact that at much higher rates than the market was expecting, along with very expensive tax cuts and not proposing to pay for them, it could create some real fiscal problems for the government going forward.
Can you describe what those problems would be? I know you alluded to or used the analogy of 2022 in the UK, but can you tell us exactly, kind of generally what
Yeah, certainly. So the concern is that and traders are not going to want to buy U.S. Treasuries without getting a significantly higher interest rate on return. So it could cause mortgage rates as Treasury yields to spike and to much higher levels, which would make it much more expensive for the government to service its debt and would also increase both residential mortgages and likely result in higher mortgage rates for the commercial market as well.
Do you know where the proposed extension of the tax cuts stand today?
It's still in negotiation. There isn't the House and Senate plans are not in alignment, which is pretty typical for at this point in the process. So there's going to have to be some reconciliation done to get through. And unsurprisingly, the House is proposing much deeper cuts than the Senate is at this point in time. The Senate tends to be more conservative on this. So it's going to have to go through a budget reconciliation process, and we'll see where it comes out through there. And obviously, the president has a lot of influence on how this is going to go.
And before we move on to franchise regulation, do you have any sort of final thoughts for our audience in terms of bankruptcy and restructuring and what to look for this year, or what to prepare for this year?
I think, the economists overall are all more concerned about the potential for a recession, and the estimates I've heard range, 40 to 65% that we end up in a recession this year. From what we're seeing already, companies are reforecasting for the year, and you're hearing a lot of companies already predicting lower profits and lower revenue this year going in. So I do think the prospect of a recession is now on the table, whereas it didn't really seem like that. It seemed like the Fed's soft landing was coming into focus, and now with the turbulence over tariffs and the market disruptions on there, I think there's a lot more uncertainty there. And I think continuing to watch the job markets, the hiring figures and the unemployment numbers going forward is going to be critical on, as an indicator of where things are going and how the government will respond.
Well, thank you, James. I appreciate your thoughts today. Next, we're going to be taking a look at what franchisors can expect from the Federal Trade Commission in 2025, especially in light of the new administration, changes in leadership at the FTC, shifts in policy priorities, regulatory enforcement, et cetera. To help walk us through those developments, we have today John Skelton, who is one of my partners in our Boston office and co-chair of our franchise and distribution practice. Hey, John, welcome.
Hey, Ken.
So, question for you. How might the recent changes to the makeup at the FTC impact the agency's franchise-related enforcement?
Well, first, hopefully my little discussion here is going to be more uplifting than James, that was a lot of doom and gloom. But we are, there's a lot of uncertainty. And, in franchising, it is what we saw in 2024 and what we expect to see carrying on into 2025, notwithstanding some of the changes to the makeup of the FTC with their new chair, Andrew Ferguson, who's probably going to be more business friendly and bring a more business friendly, franchisor friendly approach. We're still likely to see the policies that the FTC has been undertaking in 2024 with respect to franchise regulation. We're going to likely see that continue. The key theme in 2024 and continuing into 2025 is transparency and disclosure. A lot of consumer protection activity at the FTC, and in the franchise relationship. In mid-2024, there was a number of policy statements and position staff policy statements and the like, staff guidance, which aren't necessarily law, but really signals where the agency is going. And, the nuts and bolts enforcement does take place on the staff level. And what they were really looking at and what we expect to, continue is wanting to make sure that franchisors are not including in their franchise FDDs and franchise agreements restrictions, whether through non-disparagement, confidentiality, or other similar kind of pretty standard provisions restricting franchisees from making complaints to the government. You saw that with Chris and Teddy talking about whistleblowers and the like. There's very much a concern that franchisees might be restricted from going to regulators to say, hey, my franchise system is violating certain rules. So that focus, I think we will continue. Consistent with that transparency and disclosure, another thing that we saw last year was a real concern about undisclosed fees. I sign up for a franchise system, I make an investment. The FDD tells me what my upfront costs are going to be, what my fees are going to be, but all of a sudden there's a policy change or something in the operations manual that says something changes, and lo and behold, I am now subjected to another new additional fee. That is something the FTC has frowned upon. They have taken regulatory enforcement against it, and we continue to see that. And so that means that franchisors in 2025, and we're in the middle of the FDD renewal season right now, should really make sure that all of their fees are adequately disclosed. The other thing that we saw in 2024, and we will continue to see, notwithstanding the FTC changes, is they went out and did a survey. What are the biggest franchisee concerns or problems or complaints or the like? And fees and those undisclosed fees, supplier restrictions, i.e. you're forcing me to buy only from certain people. Oh, and by the way, if you're getting kickbacks from those suppliers as the franchisor, and early termination, liquidated damages provision. So there's a number of things that go to kind of the underlying fairness of the system. The FTC wants to make sure all of that is adequately disclosed so that those franchisees can make a informed decision. And one other thing that we're seeing now is, and again, the FTC is federal. We've got a bunch of states that have their own franchise regulation laws, California being one. California often leads on a number of regulatory enforcement activities, and they have recently are focused on franchise brokers who are out there selling the franchises and making sure that that now they have to have registration and some disclosure. Again, that theme of disclosure. So the last thing that I think that Andrew Ferguson is going to, hopefully focus on, and he's going to get what I'll call in the franchise world bipartisan support on both the franchisor side and the franchisee side, is the FTC franchise rule itself. Usually, about every decade, it comes up for renewal. It's long past due, and I think that there's some effort to take a look at that, update it, focus on the regulatory enforcement activities, and make sure that they are as up to speed. I'll touch upon, something a little bit later, but one of the things that new administration has focused on is, making sure regulations are as business friendly as possible, and taking a new look at that FTC rule, I think, would be an important first step.
Well, you kind of anticipated my next question, because I'm curious whether the administration's executive orders are having an impact on maybe the rule you're talking about, or just enforcement priorities for the FTC in general.
It's across the board. And a lot of those executive orders, have been creating a lot of uncertainty and turmoil, across a wide spectrum of industries. But with respect to franchising and what I'll call FTC regulatory enforcement, they very much have been focused on reducing regulatory roadblocks. And you see a lot of activity now at the DOJ and at the FTC regarding for example, the antitrust enforcement. And most recently, the DOJ announced that they have now an anti-competitive regulation task force. So they're looking, specifically going out into the regulatory world and looking at existing regulations that may be hampering competition and may be affecting businesses negatively. And while not specific, that DOJ task force, while not specific to franchising, certainly does reflect, I think, that pro-business outlook that the administration is focusing on. Not specific to an executive order, but one of the other things that you see from the new administration that relates specifically to franchising. For the last 10 years, the joint employer rule has been a huge issue in franchising, and something that franchisors have been very concerned about. And so the new administration is rolling that back. We're going back to the pre-Biden rule on joint employer. And I think that this is something that we're going to see the NLRB taking a look at how that is enforced. And I think that for franchisors, more certainty is certainly welcome.
Before we shift gears just slightly, can you explain the joint employer rule?
So the joint employer rule in franchising
Yeah,
is
franchising.
if there is a claim asserted against a franchise entity, a franchisee. So a lot has been in the hospitality space, a lot in the fast food industry. And so you have an employee who challenges their employer, their franchisee employer, and says, hey, you have not paid me all of the wage and hour benefits that I am entitled to. They not just sue that franchisee, but sue the franchisor as a joint employer and say, you now the franchisor. And if you just use, for example, McDonald's has been litigating at the NLRB for a number of years. If McDonald's, as the franchisor, was considered the employer of all of the workers at all of the franchisee outlets, that would be a big deal. And so the key issue there is control, how much you cannot control. There are independent businesses. You can't control the wage and hour, administrative or HR related functions. And, we have seen a lot of franchisors look very carefully at their operations manual, their FDDs, their franchise agreements, and all the related agreements, making sure that their efforts is really to control the brand and not to control the actual franchisee operations. What the current, I think what you're going to see with this, with respect to the NLRB joint employer rule, is more certainty as to when a franchisor might be considered a joint employer. Certainty is all businesses, that's what they want to, will comply with the rules, just tell us what they are.
That's a good segue. So now we'll move back to tariffs. Speaking of uncertainty to some extent, I know they're a major issue in the automobile industry, and I know you work quite a bit in that industry. How might the FTC's efforts regarding transparency, which you've talked about, and pricing and fees in the auto industry, how are those two going to interplay?
Well, I like to just back up just a bit. So with respect to the auto industry, the FTC had published their CARS rule, C-A-R-S, and it was specifically targeting the automobile industry and less than appropriate practices by car dealers with respect to disclosure of fees and transparency, and the S in CAR stands for scams. So they were really trying to focus in on the automobile industry. And as reported in our outlook, there's been a number of enforcement actions against major automobile dealer groups in the past several years. So the FTC has been exceedingly aggressive in that regard. And, multi-million-dollar fines and settlement agreements over adequate disclosure of fees, hidden fees, junk fees. The last thing that consumers want is to respond to an ad, go into a dealership thinking they're going to pay a certain amount for a car, and then at the end of the transaction find out there's another $3,000 tacked in for all sorts of stuff that no one had ever mentioned. The CARS rule was specifically targeting that. The FTC took a lot of enforcement action against individual dealer groups who were violating a lot of rules, and it wasn't just, there was a lot of enforcement activity, not just on the cars rule, because the cars rule got challenged, including by the National Automobile Dealers Association. Most recently, tail end 2024, the cars rule was, the challenge was upheld. It's now not enforced, but it was overruled not because of the substantive provisions in it, but because of the way the FTC went around the rulemaking. So we will see that, I think, continue, that kind of enforcement activity, whether it's on cars or not. Tariffs are a huge issue in the automobile industry because all of a sudden, depending upon the particular origin, the country of origin for the car, and given the price, a 25% tariff on a $40,000 car is a lot of money. And who is going to absorb the cost of that tariff? Is the automobile manufacturer, the importer, going to just take that on, or are they going to pass it on to consumers? We're actually working with a number of clients on that issue and how to deal with that. Where it comes into transparency and disclosure is if you think about advertising, all the car ads you see on TV and the like, and they advertise MSRP, they advertise lease prices. Well, do all of that advertising, have they already baked in whether there's going to be increased fees on tariffs? When you go to a car dealership and you look in the window sticker and it gives you the cost and the MSRP of the car, is the added tariff cost going to be included in the wholesale price and thus reflected in the MSRP? Or is there going to be an add-on, an import fee, a tariff fee, or other kinds of documentation? And, if the manufacturer is just going to increase its wholesale cost and thus the MSRP, well, there's probably not an issue. The minute they're going to deal with it on some sort of import tariff or other kind of fee, you get that issue of transparency and disclosure, really comes to light. And I think that one of the bigger things is advertising. Whether promotions online, TV, and the like, how you're dealing with the cost. You can't say the car is going to cost X, and then there's a $10,000 tariff fee when you walk into the dealership. Bottom line, significant issue for the industry, and again, consistent with everything that we've been talking about. The key very much is transparency and disclosure.
So along those lines, on the advertising, would the addition of a disclaimer of some sort saying, here's the current MSRP, which may change, or there may be an additional fee, something in the ad, would that satisfy the transparency rules?
Well, depends what it says. And we have done a lot of work over the last, 2, 3, 4 years as the FTC has really cracked down on both the FTC and again, you have state regulators in certain states that have really looked at the car industry and advertising, so much of which is online now. You go to websites and you go to dealer websites and the like, and you're looking at inventory. What are they disclosing on their price becomes very important. Now, if there are going to be fees, those fees have to be transparent, and they have to be adequate. You can't be fine print. Fine print will get you in trouble because it's the classic bait and switch. And a lot of state regulators have been looking at the car industry before this, and now see tariffs as an additional one. So for all of I know a lot of the car manufacturers out there are looking at this very hard right now. It's a challenging thing because the tariffs and the cost of vehicles are so great, and the amount of the tariffs, how they handle that. absorbing, passing on? If you are going to pass on, how are you disclosing it to others?
Thank you, John. Appreciate the discussion today. It gives us a lot to think about.
Thank you.
Why don't we bring everybody else back? And right now, well, there we go. And right now you have a QR code sitting on your screen with the attendance verification code, which is SS, as in Seyfarth Shaw 3804. So you can get CLE credit for this. I'll give you a minute to scan that code, leads to a form, fill it out, and provide the verification code, and you can get CLE credit. Going forward, we're next session of our Commercial Litigation Outlook webinar series, number 3, is going to be covering trade secrets, e-discovery, and privacy. It's on May 6th with several others of my partners, and hopefully you can attend that. And before we leave, I want to really thank John, James, Chris, and Teddy for being here today. Your insights are great, even if James's outlook was a little bit depressing. But thank you, everybody, and I hope to see you at the next one.